vaccines are important now more than ever for your family and your community. Hillsborough County leaders, along with local health and safety experts, are urging residents to get their flu vaccines. A flu vaccine this season can help reduce the burden on healthcare systems that are responding to the COVID-19 pandemic and save medical resources for care of COVID-19 patients. Reducing illness and hospitalization from the flu helps keep everyone safer. To prevent the flu and help stop the spread of COVID-19, here are a few tips you should know. Get your flu shot. Practice proper hand washing by using soap and water and wash for at least 20 seconds. Use alcohol-based hand sanitizer if you cannot wash. Avoid touching your eyes, nose, and mouth. Cough and sneeze into a tissue and then throw it away. Clean high-touch surfaces frequently. Some examples include doorknobs, credit and debit cards, cell phones, keyboards and mouse devices, and toilet handles. Wear a face covering when around others or if social distancing isn't possible. Stay home if you're feeling sick. If you have any flu-like symptoms, avoid contact with the public. Avoid sharing personal items and spaces with those close to you, and seek medical care early if you're feeling sick. You can help save lives by reducing the spread of viruses. We encourage you to visit hcflgov.net/staysafe for up-to-date information. Hillsborough County, along with local and federal health experts, are encouraging residents to wear cloth face masks to cover their nose and mouth when in public to help stop the spread of COVID-19. There are not enough surgical face masks for everyone, and available ones should go to healthcare workers and first responders. It's easy to make your own face mask out of common household items. The CDC and U.S. Surgeon General say you can use an old scarf, bandana, or make one using a t-shirt plus 2 rubber bands. Cut part of the t-shirt into a square, fold it from the bottom to the middle, then from the middle to the top. Repeat those steps one more time, then add a rubber band to each side. Bring each end to the middle, then secure around your face. They should fit snugly but comfortably. Cloth face coverings should not be placed on children younger than 2 years of age or people who have trouble breathing. The CDC emphasizes that while wearing a face mask, you should still practice social distancing, stay 6 feet apart from others, and continue other preventative measures such as frequent hand washing. We encourage you to visit hcflgov.net/staysafe for up-to-date information.
Flossing in the morning is a really great way to keep your teeth healthy and start the day. But when you're through, here's what you do. Throw it in the trash, don't flush it. There's a problem lots of people don't know, called sanitary sewer overflow. A condition buried deep in the ground, inside a pipe where bed clogs are found. It's a problem we can all help solve, so throw it in the trash, don't flush it. Baby wipes, bandages, cotton pads, paper towels, dental floss, clog up bad. Medicines, kitty litter, cotton swabs, hair. Throw them in the trash, don't flush it. It just takes a second to do the right thing, so toss it and let's keep our pipes clean. Throw it in the trash, don't flush it. If it's not toilet paper, don't flush it. Even if it says you can, don't flush it. If you're having any doubts, don't flush it. One more time, don't flush it.
Find your adventure here in Hillsborough County. With 25 unique trails, including 2 special ones in Florida State Parks, this year's hiking spree is going to be the best one yet. Register at hcflgov.net/hiking spree to earn this year's medallion. Show us your favorite spot by taking a picture and tagging it #TakeAHikeHC. Happy hiking!
Hello, I'm WWE superstar Titus O'Neil, and today I'm coming to you as a neighbor. You owe it to yourself and those you love to get tested now. Get the care you need and protect your family. Hillsborough County is offering free coronavirus testing and no health insurance is needed. It costs you nothing to get tested. Visit hcflgov.net/staysafe for more information and have a reservation made today. Share this with a neighbor and let's come together as a community and keep fighting to get through this. Together, we will come back stronger. God bless.
So you have now completed your emergency plan for your family. How about a plan for this family member? Protect your pets during a disaster by including them in your family's emergency plan. Start by making your pet a disaster kit. Put all paperwork into a large Ziploc bag, including a picture of you and your pet, your contact information, vaccination information, and special care instructions. In addition, you should pack certain items to help your pet during the emergency. A 7-day supply of food with bowls, a travel crate, and your pet's favorite toy. Remember, shelters are the place of last resort. Your plan should include being far away from the disaster's epicenter. But if you do find yourself at the shelter, know the rules. Once at the shelter, your pet will be placed in a designated animal section. This is for your pet's safety, as well as other shelter residents. Knowing the shelter rules helps everyone stay safe during an emergency. For more information about shelters, their location, rules, and how to get ready for a disaster, go to hcflgov.net/staysafe.
Is your local business or organization looking to give back to the community? Help keep our roads clean by joining the Adopt a Road program administered by Keep Tampa Bay Beautiful. Keeping our roads clean is a great way for team building as well as exposure for your business. Select the road your business wants to adopt and dispatch a team to remove litter and debris. Participants will receive 2 signs showing their organization's name as well as safety equipment and instructions for cleaning roads. You can help keep Tampa Bay beautiful by adopting your own road today. To learn more, visit hcflgov.net/cleanhc.
So let's say that Tim here was returning to his vehicle only to find it missing. He may think it was either stolen or towed. Let's not worry too much, Tim. Hillsborough County wants you to know the rules and regulations should you find yourself stuck in this unfortunate situation. Here are a few rules and tips you should know. Rule number 1, permission to tow. Towing services need permission to tow from private property and must post signs with telephone numbers saying that the trespassing vehicles will be removed. If your vehicle is missing, look for a sign and call the number. Rule number 2, communication. As soon as your vehicle is delivered to the local towing facility, towing services must notify local law enforcement within a 30-minute time frame, and they must return calls from vehicle owners within 1 hour. Helpful tip number 1. Law enforcement can help motorists determine if their vehicle has been towed. If you don't see a posted sign, call the authorities on the non-emergency line. Rule number 3, retrieving your vehicle during a tow. Most people are unaware that you can still retrieve your vehicle while connected to the tow truck. For a drop fee of no more than half the towing rate, the tow truck operator must release the vehicle to its owner. When it comes to payment, tow truck drivers must accept the following: debit, cash, cashier's check, or money order. Rule number 4, personal property. If the owner is unable to pay the drop fee and their vehicle is in the hands of the towing company, owners still have the right to retrieve personal property from their vehicle. Helpful tip number 2. Having a registration and title in your name will make it easier to recover your vehicle. Tow companies will not hand over the vehicle if you are not the registered owner, unless you have an original notarized affidavit signed by the registered vehicle owner. Remember, Hillsborough County is here to help you. For complete, detailed information on towing rules and regulations, please visit us at hcflgov.net/consumer protection or give us a call at 813-635-8316.
Tampa Bay is like no place else.
Wait, you can't recycle the bag. You have to throw it away.
Proper recycling keeps it that way for everyone. Bags tangle in machinery and can bring sorting efforts to a halt.
No bags.
Trash the bags and keep our recycling program moving forward.
No, Mom, look. No plastic bags.
Do your part to keep our recycling bag-free. Trash the tanglers or return them to participating retailers. For more information, visit tampabayrecycles.org.
This is a battle we've never faced in my lifetime. I want to tell you about 416 of the most amazing people. Every day I get to see their skill, professionalism, and dedication. Their commitment to protect and improve the health of everyone in Hillsborough County. The last 2 months, they've been on the front line of a battle with a very dangerous enemy, COVID-19. And they've risen to the challenge in the most amazing, heroic way. Everyone has contributed, sacrificing their personal life, which they put on hold. They're making a difference for everyone they help. And every day I get stopped and told just how amazing they are. I'm proud and blessed to work with them, my second family.
Flu vaccines are important now more than ever for your family and your community. Hillsborough County leaders, along with local health and safety experts, are urging residents to get their flu vaccines. A flu vaccine this season can help reduce the burden on healthcare systems that are responding to the COVID-19 pandemic and save medical resources for care of COVID-19 patients. Reducing illness and hospitalization from the flu helps keep everyone safer. To prevent the flu and help stop the spread of COVID-19, here are a few tips you should know. Get your flu shot. Practice proper hand washing by using soap and water and wash for at least 20 seconds. Use alcohol-based hand sanitizer if you cannot wash. Avoid touching your eyes, nose, and mouth. Cough and sneeze into a tissue and then throw it away. Clean high-touch surfaces frequently. Some examples include doorknobs, credit and debit cards, cell phones, keyboards and mouse devices, and toilet handles. Wear a face covering when around others or if social distancing isn't possible. Stay home if you're feeling sick. If you have any flu-like symptoms, avoid contact with the public. Avoid sharing personal items in spaces with those close to you, and seek medical care early if you're feeling sick. You can help save lives by reducing the spread of viruses. We encourage you to visit hcflgov.net/stay safe for up-to-date information. Hillsborough County, along with local and federal health experts, are encouraging residents to wear cloth face masks to cover their nose and mouth when it
issue. Good morning. This is a hearing with the land use hearing officer, procedures. First thing we'd like to do is stand and take a pledge of allegiance.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Are there any known changes to the agenda?
Yes, sir. We have one change to the agenda. That is with regards to item G11, variance application 20-1284. The applicant is Divi Sardu. We've been contacted late yesterday by the applicant's representative that due to unforeseen circumstances, she was not able to attend this meeting. Also, due to those circumstances, she actually cannot even access the meeting by virtually. So in a case like this, because they didn't ask for the variance far enough in advance to be reflected, continuance to be reflected on this, you need to make a determination as to they're requesting a continuance to the December 14th land use hearing officer meeting. Procedure is to see if there's anyone in the audience or virtually that's either here in favor or against the variance, to advise them of the request for a continuance, and if they have any comments about the continuance, not the variance, but the continuance.
Okay, I would ask if there is in fact anyone here for application number 20-1284. The applicant is, I believe, Divi Sudi.
Divi Sardu, I believe,
Yeah.
But the representative is not available, so they've asked for a continuance to December 14th.
Based on that, I would grant the continuance to December 14th.
Thank you, sir. All right, there are no published continuances or withdrawals. Before we go any farther, I'd also like to introduce myself. I am Tom Hisnam with the Development Services staff. To my left is Carmen Mason. She's also with Development Services. And we are being joined virtually by Mary Dorman of the County Attorney's Office, as well as a number of other staff of Development Services that will present the findings for each one of these variances.
All right, in terms of procedure, the hearing today is informal. Questions shall be confined as closely as possible to the scope of direct testimony. As a land use hearing officer, I will call and question witnesses as necessary and appropriate, and I will decide all questions of procedure. Moreover, irrelevant, immaterial, and unduly repetitive evidence will be excluded. Any part of the evidence that may be received in written form and all testimony shall be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but it shall not be sufficient in itself to support a finding by me unless it would be admissible over the objections in a civil action. The order and time of allotment for variance applications shall be as follows. Administrator, summary of application, county staff and department findings, 5 minutes. Applicant and witnesses proposal, 15 minutes. Proponents, argument for the application, 15 minutes. Opponents, argument against the application, 15 minutes. Staff, amended recommendations, if any, 5 minutes. Applicant, rebuttal and summation, 5 minutes. For good cause shown, a land use hearing officer may grant additional time. Please give your name and address first, speak clearly into the microphone. When complete, sign the clerk's roster. And then if there's any testimony from the county attorney, that would be next. And at this point, are we administering the oath?
Sir. At this point, sir, the assistant county attorney will explain appeals rights to everyone.
All right.
Norman?
Good morning. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decisions of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. Number one, the applicant, or number two, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the Appeals Board disregard evidence or testimony that outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Appeals Board. Thank you.
Thank you. And are we ready for the oath now? Anybody that will be testifying in this hearing, I would ask that you stand and raise your right hand and repeat after me. Do you solemnly swear to present the evidence in this matter before me, which will be truthful and based upon your knowledge of the issues involved?
I do.
I do.
Thank you.
I do.
I do.
Okay.
Do.
All right. We have no vested rights applications, which then takes us to section C of our agenda, fee waivers. The only fee waiver case is item C1, fee waiver 21-0002. The applicant is Walter Smith. The applicant is requesting a fee waiver exception. Staff findings will be presented by Colleen Marshall.
Good morning, Colleen Marshall, Development Services. The petitioner is requesting a fee waiver based on staff error. SU 19-1174 was first scheduled for hearing on November 18th, 2019, and therefore October 19th, 2020 was the last hearing date on which the case could be heard. However, the signed notice for the continuance from the September 29th, 2020 Land Use Hearing Officer hearing to the October 19th, 2020 Land Use Hearing Officer hearing was not posted by county staff. Consequently, the case was out of order for the October LUHO meeting and could not be heard, and the application was withdrawn. The petitioners filed a new special use application and is requesting a fee waiver on the basis of staff error due to the posting error for SU 19-1174, which necessitated the filing of a new special use application. The administrator is not authorized to grant fee waivers on the basis of staff error. Therefore, the subject request must be reviewed for approval of an exception by the Land Use Hearing Officer. Happy to answer any questions.
I see no indication for any questions.
Thank you.
Ask for the applicant, please.
Guys, the applicant present? Would you approach the podium, please?
Good morning. I'm Walter Smith II. I am the acting agent and applicant for 21002. I can look up there. For the fee waiver.
All right.
And I am asking for the fee waiver to be approved for this particular case.
And what is the basis for your request?
On the basis of the request is the information that was submitted to us from the zoning department that let us know that we needed to do a fee waiver and that we would do the fee waiver because of the situation where the signage had not been posted on time for this particular case, for the hearing case.
So you're responding to someone's request?
I'm sorry?
You are responding to someone's request to do this fee waiver?
No, we were informed that we need to do a fee waiver.
And I see another gentleman standing. Oh,
yes.
Is that all your testimony?
Yes.
Yeah, see, he had been advised by staff that if he wished to seek a fee waiver for the new application on the basis that the old one couldn't go to its final scheduled hearing date because of staff error in the sign posting, he was advised he had that opportunity, and he's taken advantage of that opportunity.
All right. Thank you very much.
Thank you.
Please come sign in.
Yeah.
Close the hearing.
And at this time, we would close that hearing.
All right. That takes us to, we have no reconsideration requests or site development variance requests or sign variance requests on today's agenda. That then takes us to section G, general variances. First case is item G1. Application 20-0899. The applicant is TSP Companies Incorporated. They're requesting a variance to accessory structure requirements and lot development standards. Staff findings will be presented by Steve Beachy.
Good morning, Steve Beachy, Development Services. The applicant is requesting a variance for the purpose of constructing a proposed detached garage on a lot zoned RSC 6. The applicant is also requesting two variances that became evident during the review of this application involving a side yard setback and a minimum lot size required by utilities. For the detached garage, per Land Development Code 611-04C1, accessory structures are permitted in the front yards at twice the depth of the required front yard or 50 feet, whichever is less. The required front yard setback of the RSC district is 25 feet. The applicant requests a 42.9 foot reduction to the required front yard setback to allow a setback of 7.1 feet from the north lot line along Magnolia Street. The second variance request is the applicant is requesting a 0.01 foot reduction to the required side yard setback to allow a setback of 7.4 feet from the west lot line. Again, the RSC 6 district is the required setback is 7.5 feet. the minimum lot size variance per Land Development Code Section 60106, the minimum lot size of 1/2 acre, 21,780 square feet of upland is required for the use of a septic system. The subject lot is served by a septic system, and the applicant requests a 14,391 square foot reduction to the required minimum lot size to allow septic on a lot that is 7,389 square feet in size. The subject lot was platted in 1962 as part of the Magnolia Beach Unit Number 2 subdivision, therefore was legally non-conforming to the minimum lot size required for a septic system. However, in 2008, prior to the purchase of the property by the applicant, the owner conveyed a 1.83 foot wide strip along the eastern property line to the adjacent property. As a consequence of this action, the legal non-conforming status of the lot was extinguished. Therefore, the subject to the subject approval to the requested lot Therefore, subject to approval of the requested lot size variance, certified parcel must be obtained for the lot as presently configured prior to issuance of building permits. That concludes my comments.
Is there anybody here representing the owners of this property? People requesting the variance?
Yeah. Good morning. My name is David Wright. For the record, my name is David Wright, president of TSP Companies. Our address is P.O. Box 1016, Tampa, Florida 33601. I'm the spokesperson for the property owner, Mr. Scott Segro. And Mr. Segro is also logged into this meeting, and he'll make a brief statement after my presentation. First of all, I'd like to thank county staff, specifically Mr. Stephen Beachy, for assistance with this application that became more complicated after the initial filing. I'm presenting a request for 3 variances to the county's land development code for the property that is located at 8503 Magnolia Street in Gibsonton. The first variance we are requesting is a variance to LDC section 6.11.04.C1 to reduce the required front yard setback for an accessory structure from 50 feet to 7.1 feet. This variance is requested in order to allow the construction of a detached garage between the house and Magnolia Street. The unique and singular circumstances of this subject property that justify this request are the subject property as well as the lot to the east are so configured with a large width and shallow depth. Subject property shares a common driveway with the property to the east. Subject property's residential structure has a single car garage within the footprint of the existing residential structure via the common shared driveway. The existing shared access to the existing single car garage limits access to said garage due to the shared driveway's narrow width and turning radius into the garage area. And due to the lack of available area in the side and rear yards of the subject property, the only available buildable area for the proposed garage structure is within the front yard. Precedent has been established along this segment of Magnolia Street for carports and garages being placed within the front yards. In addition to the previously stated justification, Mr. Segro's neighbor to the east owns and operates a landscaping company and utilizes the shared driveway to park truck and trailer from time to time, which significantly limits Mr. Segro's ability to access and enjoy the driveway and single car garage. In fact, the Google Street View image associated with the subject property clearly depicts the situation where the neighbor's truck and trailer are blocking the driveway completely. During review and processing of this application, deficiencies were identified that also require correction through the variance process. Therefore, we are requesting the following variances to bring the subject property into conformance with the Land Development Code. The minimum required side yard setback in the RSC 6 district is 7.5 feet. However, the existing setback of the residential structure to the west property line is 7.4 feet. A 0.1 foot reduction of the side yard setback on the west side of the property is requested. The subject lot was platted in 1962 as part of the Magnolia Beach Unit 2 subdivision and therefore was legally non-conforming to the minimum lot size required for a septic system at the time. However, in 2006, prior to the purchase of the property by Mr. Segro, the owner of the property conveyed a 1.83 foot wide strip of land along the eastern property line to the adjacent property. A copy of the quitclaim deed is included in the record for this application. As a consequence of this action by the prior property owner, the legal nonconforming status of the lot was extinguished. We are requesting a variance to LDC section 6.01.06 to allow septic on a lot size of less than 1/2 acre. If this request is approved, then the property owner will also be required to complete a certified parcel covering the subject property and the adjacent property to the east for the present configuration of the properties, which was never done when the strip of land was previously conveyed, as it should have been. County staff has determined that this variance request must be approved prior to the processing of the certified parcel. I wish to emphasize that the requests to reduce the side yard setback and minimum lot size for a septic system are both requested to correct deficiencies that existed prior to Mr. Segro's purchase of the property, and the deficiencies were unknown to Mr. Segro at that time. We prepared a thorough and professional variance application in compliance with the county's land development code. We noticed the surrounding neighbors and property owners in accordance with the county's public notice requirements. I was contacted by Mr. John Pendino with questions about the location of the existing septic system on the subject property. However, I've not been contacted by any citizens expressing objection to this application, nor are there any objections listed in the party of record as of this morning. Based on the competent and substantial evidence that has previously been submitted into the record and also presented to you today, I respectfully request your approval of variance 20-0899. And now I would ask you to allow Mr. Segro to make a brief statement as well. Thank you.
Thank you.
Thank you. I'm Scott Segro. My address is 8503 Magnolia Street in Gibson, Florida. I just wanted to add a little bit to what David had mentioned. I'm the owner of the property there. The way the house was designed, the garage is basically a 90-degree angle turn off of a shared driveway, so only half a driveway to be able to make a 90-degree turn. It's very tight to do that, very limited access that way. I've actually scraped the side of my car before getting into the garage. I've actually blown a hose on my car because I had to turn the wheel so tight to get out. And then there's always a risk, and one of my biggest fears is that I don't want to hit the neighbor's car that's parked on their side. So, that's always a risk as well. Since I've owned the home, I've actually looked for many different ways to try to remedy this situation. I've actually explored actually going in from the front, so like actually opening the wall up in the front of the house and having access that way to the garage. However, the way the house was built, there's actually the two main supporting walls of the house are actually in the front where that would have to be opened, and the engineers have told me that's not a good idea, would significantly weaken the structure of the home to try to do that. I've also even explored trying to just take the corner off and make it maybe like a 45-degree angle entrance just to kind of soften that angle, but the same thing, it's basically like the cornerstone of the house is there, so engineers don't like the idea of changing that, so it's not really an option. As David has mentioned as well, I don't really have room in the back at all for a structure. So really the only space where there is sufficient room is in the front there. The intention is, not to disrupt any neighbors or anything like that. It's actually going to be far away from both property lines, from the neighbors on the right and left. And even with the reduction in the setback, it's still going to be over 25 feet from the street because the lot itself sits back a little bit as well. So it's not like it's going to be right up against the street or anything like that. The other thing is the color scheme of the garage is going to be matching to the house. So I'll try to make it look as good as possible so it doesn't disrupt anybody. So that's pretty much all I have. I really appreciate your consideration on this variance application.
Can you please restate your name for the record?
Scott Segro.
Mr. Degro? Hear me?
Yes.
Have you talked to your neighbors about your proposal?
Actually,
neighbors.
Oh. Go ahead.
Your closest neighbors.
Yes, I have a neighbor on the right side that also shares the driveway. They had asked what the sign was about. I had told them that it was about putting a separate garage in, and they seemed to be okay with that. They were wondering why they had to have a sign there. I thought maybe it was for some kind of much bigger project. And then the one on the left, which doesn't have the shared driveway, they had just asked what it was about as well, and I had explained to them. So they didn't seem to be too concerned. They were just more concerned about knowing what it was about.
Thank you. Is there anyone else who wants to speak in favor of this project? Is there someone that would like to speak in opposition to the project? Either here or virtually. All right. At this point, then, I think I would
get no further comments from staff.
Right. So I would close the hearing on this particular.
Well, yeah, actually, you give the applicant if they have anything final to say.
You have, as the applicant, do you have anything else you wanted to add to what you've already testified to?
This is David Wright again. No, nothing further. Thank you for your time.
Okay, thank you. All right, and at this point on this particular application, number 20-0899, we would close the hearing.
Our next application is item G2, variance application 20-1108. The applicant is Habitat for Humanity of Hillsborough County. The request is for a variance to lot development standard. Staff findings will be presented by Colleen Marshall.
Colleen Marshall, Development Services. The applicant's requesting a setback variance to accommodate a fee simple duplex unit on property zoned RMC 16. The subject property is a corner lot, therefore having required front yards along the property lines on both Market Street and Mason Street. The applicant's requesting an 11-foot reduction to the required front yard setback to allow a 14-foot setback from the east property line along Margaret Street. Be happy to answer any questions.
All right, I see a person approaching the podium.
Thank you very much.
Yes.
Thank you.
Would you state your name, please?
My name is Lynette Glass with Habitat for Humanity. I'm the Community Planning and Development Manager. We're here to request, as you heard Colleen say, we're here to request a reduction in the side setback on 234 Margaret, which is a corner lot. So therefore it has two front setbacks, each at 25 feet. The request on that front setback off of Margaret, we'd like to reduce.
Lean into the microphone a little bit when you're talking. I can hardly hear you.
Okay.
Thank you.
Is this better? Now I feel like I'm echoing. So we're asking for a reduction in the front setback off of Margaret, which is required to be 25 feet down to 14 feet. The reason for this is to try to keep our townhome concept to match the aesthetics of the neighborhood, the homes across the street, as well as the other townhomes that we were building on Mason.
Is that basically your testimony?
Yes, I'm here to answer questions. And again, I would like to also thank staff for all of their help on this, the development services staff. And also, I think it was in the application that we're building townhomes that are affordable, sustainable for households below 80% of area median income.
Right. And have you had any contact with the neighbors or the people that would be perhaps directly affected by this?
Well, Habitat owns the other two lots to the west, which would be 226 Mason and 230 Mason. And then there's Margaret Street. So there's not a neighbor on that side of the street. Not a neighbor along, next to Margaret.
Any other questions for the applicant? All right.
Am I allowed to ask questions at this point?
Dr. Hollaback, if you have any testimony, go ahead.
Okay, first of all, no one has been in contact with me. This land is directly across from my house. I've had no information.
Dr. Hallback, are you part of the applicant team or opposition?
Opposition, I apologize. That's what I'm saying. Is it my turn? I'm sorry.
All right, seeing.
I need you to fill this out completely.
Please stand by, Doctor.
Okay. Are there any opponents to this project?
I'm sorry, did you say?
I see a gentleman raising his hand. And I also think the lady that is appearing virtually is an opponent. So could we bring her up first, please?
Go ahead, Dr. Hallback.
Okay, I apologize. I seem to have some connection issues, so I hope you can hear me. But no one has been in contact with me. This land is directly across from my house. When we purchased these homes, we expected that this other land was going to be used for single-family homes because that's what we expected. I mean, we purchased these homes. These are homes that we would grow old in after our children leave. So the problem is that I haven't had any information other than they're going to build, I guess, multiple family units when that's going to create a serious injury to us. I was looking over the different areas of, I'm sorry, let me get to that. So when I was looking about the application process and procedures, I got to explain how the variances, if allowed, will not substantially interfere or injure the rights of others whose property would be affected by the allowance of variance. Okay, so I'm not sure if this is exactly where I should be, but we don't agree with the entire site being built as a multifamily home because we have a significant portion amount of traffic. It's become dangerous. We have been hit. The police have been called. People have been violent with us. We have a disproportionate amount of traffic in this one little street. And building a multifamily unit versus, a single family home is not going to bring 1 to 2 cars, maybe 4. You're now talking about a possibility of 2 per family or more. This is already a bad traffic area. I've spoken with Hillsborough County. The last time was on the 13th, September 13th of 2019, because we have such bad traffic. Everybody, they speed through there. It's a danger. They've knocked down poles. We can't walk our children. There are no sidewalks for us. And we understood that buying this property, but we also were under the impression, since it's going to be a single family home, this would not be this bad. And we're not being helped. None of this is being addressed. Like I said, the last time I spoke with Hillsborough County, and it was supposed to be Sergeant Brian, no one even responds to our requests. I've owned this property for 9 years. So no one has been in touch with me. And none of us agree that this is a wise choice, as this is a very complex subdivision already with businesses and homes. But if to add another multifamily unit to an already overly congested area for traffic and all those things is unfair. So I'm not sure if this is where we are at this part of even being opposed to the entire project. We understand that until this property is in use, it doesn't allow us to really enjoy our land or enjoy the value of it. But to put a multifamily home would not only take that away from us, it would cause us a substantial amount of injury. And no, this is not a taking, but it's going to reduce our value of our property, but it's going to raise our property tax. It's working in a negative. Like I said, there's so many negatives to have this here, and most of all, it's the injury to us as the individual homeowners.
Okay, ma'am, we appreciate.
Please state your name and address for the record.
Dr. Shalonda Hallback, 217 Mason Street, Brandon, Florida, 33511.
Thank you.
All right, I saw somebody, a gentleman with his hand up. Would you approach the podium, please? And state your name, please.
Name is Quentin Hicks, 223 Mason Street.
And what would you like to?
I've been in this area here for over close to 10 years. I'm pretty much one of the very first ones. By bringing in two the duplexes in there, it will cause a major problem. A major problem. You consist of 2 vehicles per unit, and then additional if they have children or whatsoever. So it's going to be overcrowded. And by plugged in on that side of that, on the corner and adjacent to that, it's just going to bring even more and more. Mason Street used to be, and still is, a cut route from the hospital. We got Brandon Hospital right there. There used to be a cut way to travel through to get to 60. It has been cut down a little bit. We used to have the sheriff there parked down on the corner and also issue out tickets, but with persistent going on, it's kind of like deviate and push people back on the main road, which is Partisan Road. But I am very, very concerned with that. It brings in more and more traffic, as well as more people piled up in one area, more issues. I do record that section, that street. I do have cameras up and down that street and record all action that goes up and down, and I do report it to Hillsborough County Sheriff. But like I said again, I do oppose this. Thank you.
Is there anyone else in opposition? Please state your name, please.
Latasha Walters Jackson, 221 Mason Street.
All right.
Okay, I have opposed of them building multifamily homes. That property as well is directly across the street from my home. And as the other two opponents were saying, that street is very dangerous. Everybody cut through off of Parsons to come through Mason. The street is very, very narrow. And then they make a left to go on Margaret, which is a short street as well, to come out on Robertson, or go straight up Margaret to go to Highway 60. Our homes that we purchased 10 years ago was over 200 and something thousand. It was going for 400,000 back then, but we ended up getting a great deal, over 200,000 for the home. So them building Habitat townhomes across the street would really bring down the value. Already the street is narrow, so you're talking about more people, more cars on a narrow street that's not even big enough for 2 cars. People sometimes have to wait for people to pass by, depending if we, as the homeowners, already have 2-3 cars, and then if we have to park on the street, it's just not enough room to have a multifamily homes that's right across the street from us. And there's no speed bumps because they can't put speed bumps because the ambulance have to, that's like a escape way for them to get to the hospital. So they cannot put speed bumps on Mason Street, along with the commercial lawyer's office and more commercial building that's down on the other end of Mason Street, which is right at the end on the left-hand side. It's just not a good fit for the neighborhood. So I oppose for them building the multifamily homes across the street from my home.
Were you contacted by the people from Habitat?
No, I was not.
All right. If you were to be contacted, would you be willing to talk to them?
No, I don't want any multifamily homes across the street from my home. No. Single family, but not multifamily. No. That's it.
All right, thank you. Is there anyone else speaking in opposition to this project, either here or virtually? All right. Seeing no one, we have a time for someone to speak in support or rebuttal, if you will. Would you approach, please?
Hello again, Lynette Glass, Habitat for Humanity. The zoning on this property is RMC 16, so it actually allows for higher density. So the homes can be built. We're not asking for a rezoning. We are asking for the side setback so that our townhomes can look more consistent with the rest of the homes on the block. If we can't get that, then that last townhome will not look as the other townhomes on the block. It will look different because we will have to split the lot a different way.
Okay, thank you.
As far as notifying the residents, we did follow the requirements in the variance package where we were supposed to contact everybody that was within that radius as required. And that was certified by the post office that we had all of the addresses that was on the list that was produced by the property appraiser. So we feel like we did respond, or we did let everyone know about the about the variance.
Thank you. At this time, we would close this part of the process.
Our next case is item G3, variance application 20-1125. The applicant is Jason and Jennifer Waz. They're requesting a variance to fence requirement. Staff findings will be presented by Isis Brown.
Good morning, Isis Brown, Development Services. The applicant is requesting the variance to increase. Am I being heard okay?
No, we cannot.
Okay. Is this any better?
No. Can you try one more time?
Isis Brown, Development Services.
You're good. We can hear you.
Can you hear me now?
Yes, we can. Go ahead.
Okay, all right. Good morning, Isis Brown Development Services. The applicant is requesting a variance to increase the maximum height permitted for an existing fence on a flag lot zoned ASC 1. Per LDC, per Land Development Code Section 6.07.02, Part C, Number 2, fences in the agricultural district shall be regulated in the same manner as fences in the residential district, except under certain circumstances that do not apply in this case. Per LDC Section 6.07.02 C1A, fences over 4 feet in height shall not be allowed within the required front yard except under certain circumstances that do not apply in this case. And the fences over 6 feet in height shall not be allowed within the required side yards. The applicants are requesting a 4-foot increase to a maximum fence height permitted in a required front yard to allow a height of 8 feet of an existing fence. Which is depicted by the blue line on graphic within the front yard on the south side of the lot. The applicant is also requesting a 2-foot increase to the maximum fence height permitted in a required side yard to allow a height of 8 feet for an existing fence depicted with the red graphic within the required side yard on the east side of the lot. Findings per survey, the findings for this case, per survey calculations, the property is approximately 1.027 acres in size rather than the 0.99 of an acre as stated on the application, and therefore is conforming to the minimum lot size of a 1 acre required in the ASC 1 district. Another finding, per LDC section 6.0103 F9, required yards shall be oriented with respect to the roadway from which the flag lot is accessed, as if the lot abutting the road. In this subject case, the lot is accessed from Crenshaw Lake Road to the south, resulting in a required front yard on the south of the lot, required side yards on the east and west, and required rear yard on the north side. This ends my comments. I am available for any questions.
Is there anyone here representing the applicant? Or would you come forward, please? Are you together?
Yes, we're Jason and Jennifer Waz of 17107 Flor del Sol Road.
State your name, please.
Jason Waz.
Jennifer Dawson Waz.
And go ahead.
Well, up until recently, the past few months when we were doing research for this variance case, we actually had no knowledge of the bizarre circumstances that affect our house. More specifically, we learned what a flag lot was. We figured this out about a year after we actually lived in the home, where our backyard is actually our front yard, and our front yard is actually our backyard. So where the fence was put up, are you able to bring the picture back up? The diagram, or no?
And we put it, we have one to use.
So to the right of the screen is south. The blue line is where the fence is erected to the south of our property. And so that's actually our backyard. The front of our house is actually facing to the left. And there's two easements or roads that lead from Crenshaw Lake Road. On the bottom of the diagram is Flor del Sol, which is actually how we access our front driveway. And then the road to the back, Hacienda del Sol, is actually in disrepair, and there's a gate that blocks access to that road. So what they consider our front yard is where the blue line is, but it's actually our backyard. And the two neighbors behind us, their backyard already has two privacy fences that are in various levels of disrepair. So they already have a privacy fence that's in our backyard, but it's considered our front yard based on the flag lot. When we purchased the property, we were informed that it was a private development of 4 to 6 lots, which had its own homeowners association. And we were under the impression that Flor del Sol Lane and our southernmost property line and easternmost property line were the boundaries of the perimeter of the small subdivision. To the southeast, top right corner, there's actually a adult group home, which is a business there. It's called, what's it called?
Angels. I would have to look it up, but I think it's Angels Care.
And so we actually tried to put a buffer in that area, and we went to great lengths to do some landscaping. We added Leland cypress trees all along the back of that fence, which was in disrepair, and the trees died about 2 months after we put them up there. And so it wasn't until we put a pool in the back of our home that we actually decided to put a privacy fence that was backed up to their fence, which was in disrepair. One other thing, the top of that diagram there where the red line is, which is also where we put the 8-foot privacy fence, right about where the red line the vertical red line comes down where we finished our fence. That's where somebody put a locked gate on Hacienda del Sol. And it's actually a through street from north to south. And because there was a gate there before we had our fence, we would have cars coming from the north heading toward the south to Crenshaw Lake Road. And they'd actually make a detour to the west onto our yard to get around that locked gate. And one time our Yorkie was actually in the backyard and he almost got hit by cars taking a detour onto our lot. Also to the left of that red line is where our septic drain field is. So there people were driving over our septic drain field to get around that gate that was locked on Hacienda del Sol. Just above that on the diagram is Horn Road, which is actually a through road that's still paved that you can get all the way access from north to south, just parallel to Hacienda del Sol. So that road is actually intact there. And so we really just put up the fence to mitigate potential risk with the group home that was behind us. And I should note in the backyard where the group home is to the left, to the right of that diagram, they actually have a structure in the back of their property, which is a shed that is the roof is about 10 feet off of the ground. And the roof is in such disrepair that whenever there was any wind, the roof would actually like bang back and forth. So we felt like we had to put an 8-foot fence there to mitigate the risk of that flying off into our yard, injuring somebody. So that was the other reason that the fence needed to be that high in that area. So really it's just the area to the south of our property and to the east of our property where we have the fence. Everywhere else on our acre of land, we don't have any barriers or any fence because we felt like there wasn't any risk or any, for any injury or we had to mitigate any of that. And I just wanted to also say that we absolutely are not trying to usurp any of the rules or laws or zoning because of, putting the fence there. We actually had a letter that was written, signed, and approved by the president of the Homeowners Association, who also lives in our property, before we put the fence up, which was given to the fence company. And it lists the fence regulation section 6.07.02 on the letter that was written by the Homeowners Association that was given to the fence company. So we now realize that we were naive to think that the fence company and everybody was following all the rules, but we assume that since there were many 8-foot fences all along Crenshaw Lake Road, since we were on private property, in a private housing development, thinking that was our backyard and trying to mitigate the circumstances that I talked about, we felt like it was the best thing to do to improve the neighborhood, to make it safer, and to, like I said, prevent people from driving onto our property. I mean, there were times where Amazon and Uber Eats will come in off of Hacienda del Sol, drive into our backyard at night to make deliveries. So you can imagine, at certain points we thought people were breaking into our property before the fence was there because the way the lot is and the way Google brings people there brought them from Hacienda del Sol onto our property into our backyard at night to make deliveries. So since we've had the fence, we haven't had that issue, obviously, of people driving into our backyard or driving around that lock gate on Hacienda del Sol. One of the last things that I was notified of is Hacienda del Sol is actually the official way that we're supposed to get onto our property. But Flor del Sol is the road and the private driveway that was created when our house was built. So we really have no access to our home through Hacienda del Sol, which is why, the fence is there to prevent traffic from driving onto our yard when they try to go from the through street from north to south. Okay.
So just for the record, Hacienda del Sol is actually a dirt road. So the main road to get to our property is Crenshaw. And so there's a dirt road now that runs through our property. We've only been living on the property for a little over a year. And we bought it not realizing all of these things. None of these things were brought to our attention. But having children and pets and having a dirt road that most people think on a Google Maps is our road. We have a pool. They could literally drive into our pool. So we had to create some type of barrier, and we had to create a barrier that, again, would curve around. And when we bought the property, we did not understand that the two houses on the other side, one of the two is a business. We had no idea. I don't think we would have bought it had we known we were going to be backed up to a business with residents in the backyard with their fence is short of, yeah, it's falling apart. It's definitely a safety concern for children. And they also have things in their backyard that, which we have pictures of, that could easily blow onto our property and be very dangerous as well. Hence the 8 feet that we went to try to block off any danger to our children and our property. Thank you.
Is the fence up?
Yes.
Okay, so the fence has been by a fence.
We didn't know there was anything wrong with it until we had notification that we would have to, if we wanted to keep it, get a variance.
We have 2 neighbors on our same street, and we have pictures of it as well that have an 8-foot fence. And so the fence company sold us the fence. We have neighbors on Crenshaw that have that fence. So we had no idea that it would be a problem.
Do you know if the fence people pulled a permit to put your fence up?
I'm not sure. I guess they did. I mean, they're a company that's been in business for a long time, so I assume they did all the proper, surveys and permits to get it done.
I brought all the paperwork if you need copies of or want to look at the stuff that Florida State Fence, the company that put it up, gave us. I also spoke with the owner of the company, pleading, why would you sell us a fence knowing that it was illegal, possibly not legal, and they had no response.
And we had no idea, especially like in our backyard, which is considered our front yard with the flag lot. It says we should only be able to put a 4-foot fence there, but the neighbors to our backyard already have privacy fences there. So for us to put a 4 fence below where their fences are is kind of, it's just the way the flag lot is, which I'm understanding now that it doesn't make sense the way what they're calling our front yard and our backyard.
Well, has your fence in putting it up been cited? And who's objecting to your fence?
We had a zoning officer come to our house that said that, and they cited us and said that we either had to get a variance or take it down.
All right.
And like I said, we've already invested a lot in landscaping. I bought about 30 Leland cypress trees to try to buffer that, and they all died. So, I think our land is just cursed at this point. Definitely not a fertile ground, but we did that. We had to have all those trees pulled out to put the fence up. And, again, now we know we incorrectly assumed that it was within code to put the fence up, but we're asking to be able to keep it so we don't have to start over with, mitigating the risk and the safety and, the neighborhood.
All right. Well, thank you.
Thank you.
Hello. If you'd like to use the overhead projector for anything, you can. Yeah, I know you have photos and things.
Yeah.
If you do show something, though, you're going to have to turn it into the clerk.
Yeah, we have copies.
So you don't keep your only, not your only copy.
Are we able to do that?
Yes. The attendant here can help you turn it on.
Okay. This is one of our neighbors. This is one of our neighbors' 8-foot fence that is 5 houses down from our fence or our property. So you can see the step up. Is it here? Well, no, wait. You can see the step up here. It goes all the way around. They started lower and then it goes all the way around the whole property.
I need you to talk into the microphone, please.
Sorry. I'm trying to mark it. And, but you can see the step up over here. So again, being new to the neighborhood, having no idea, this is one of the people that are 5 houses down from us that have it around the whole back of their property. Their property is a little bit larger than ours. And then there's another house that is about 8 houses down the road that also has it in between 2 houses. This one I'm not sure. It looks like there could be some type of business back there. I'm not sure, but the other one is 2 residential properties in between the 2. Yeah, go ahead.
Okay, the red circle shows the structure of, that's the group home with the rusted roof structure that's sitting about 3 feet above their privacy fence. And that was the initial stimulus for us to put up an 8-foot fence to try to mitigate that from, coming into our yard. Anytime that it blows or it rains, I mean, that whole thing is rattling. And so that was the reason for getting the fence to an 8 feet originally.
That's supposedly our front yard.
I need you to speak into the microphone, please.
Yeah, this is what they consider our front yard. This is a picture from our pool cage looking at the backyard. So this is where the code says we should only be able to put a 4 fence up against their privacy fence.
Excuse me. In that photo, is the roof that I'm looking at, is that your home?
That's the home behind us. That's the group home with the rusted roof that we're trying to, prevent against from coming into our yard on the, not the house, but that's actually a shed structure that's in their backyard.
Thank you.
This is what our yard looked like before we cleared it and put the trees there to try to put a buffer. The arrows show the Leland cypress trees that we had planted that died within a couple of months. So again, we try to do everything possible to prevent having to put a fence up. But to the left where Jennifer's hand is, that's Hacienda del Sol.
This was before
Ma'am, I need you to speak into the microphone.
This is before there was a pool there, but this is where people would just drive right. You could literally drive it into our house.
So,
excuse me.
So the other part of the fence.
So let me ask you a question.
Right here.
The porch or structure on the right, my right, probably your left. Is that your house?
Yes, that's part of our back porch before the pool was put in.
All right, thank you.
So we're looking south in this picture. And this just shows you Hacienda del Sol. That's the water truck that's putting water in our pool and how the cars and trucks had access to that. Just behind that truck, though, if you go to the left of the picture, is where the gate is blocking Hacienda del Sol. So people would come around that gate toward our pool cage to get around our yard, into our yard before we put the fence up on that side.
Thank you.
And I just want to show you a picture of what it currently looks like with the fence. This is actually the gate that's blocking Hacienda del Sol. Our house is to the left of that. This is looking north on Hacienda del Sol. And this is our fence. If we're looking south now, our fence is the white fence, and the fence behind that is the fence. That's the side yard of where that structure was with the rusted roof.
What is it that, I think it must be your wife's finger, she's got fingernail pollen. What is that?
That's Hacienda del Sol, and that's Crenshaw Lake Road is where her finger is. So that's the main road that has access to our property with these other 2 homes behind it.
Road?
Yeah.
Okay.
And that's the road that people would pull to the right of the picture onto our lot to get around that locked gate that I just showed you before we put the fence up.
Thank you.
This is one last picture. This is looking from Crenshaw Lake Road, looking the opposite direction, looking toward the north. And you can see the white fence just behind the bus, which is where our fence starts and where their fence ends. I have copies of all these labeled that I can put in the record.
So that now, this is the way it looks now. So now that when you turn off this and you drive down here, you can no longer drive into our backyard at all. It completely sealed it off, and that yellow sign is your sign for this variance, and that's the private gate. So again, before this fence was there, you could drive and go around and go to those people's property back there. They, you know, like they could drive around that gate, and now it's all fenced off so that nobody can drive. You have to use that gate to get back there, and nobody can drive into our property.
Thank you.
Thank you.
Are there any other proponents of this request in the audience? Are there any opponents, people that are against this request in the audience or virtually?
Good morning. How you doing? My name is Elaine Colson Powers. I live catty corner across the road from them. They have been talking about roads that access Crenshaw Lake Road. They are both private roads. They do not cut through. They're not supposed to. People do that, especially on our road. Not so much on their road anymore. My address is 617 Crenshaw Lake Road, Lutz, Florida 33548. I've lived at this address for 34 years, so I've seen a lot of things come and go. I've been before y'all before on issues, and I appreciate all you do. Thank you very much. I would just like to let you know why I'm in opposition to this 8-foot prison wall privacy fence they've put up. I have no objection to a regular 6-foot fence, which is to code. So this fence is not to code. It was just put up in August, or maybe the month before, July. Yes, there were problems with people coming down the road, and there still is, because Amazon believes we have a through street, which we do not. So they try to access the subdivision behind us. We only have 3 people who have access to our road. We have since put a gate at the back. And by the way, even that gate they're talking about is not even supposed to be there. And they don't even have access to that particular road. It's a private road. It's part of their subdivision, but their access is the next road. Okay, so it's kind of confusing, I understand. But like I said, I've been there 34 years, seen it all. I can tell you exactly what happened from step 1 all the way to today. So, since it doesn't meet the 6-foot code, it's an 8-foot fence. I mean, I have no problem with 6-foot. We are a wood and wire people. We have no plastic white fences in our area. And the ones they're talking about, the one that they showed you pictures of, they said it was uneven and it was a flat step up. And you and I both know that the reasons that y'all grant variances for larger or higher fences, maybe because there's a 2-story building next door, or a home that's too close. They have nobody next door except for the ALF and another person, and they both have 6-foot privacy fences that are already up. And if they're not up to code, perhaps they should be cited. And I can understand them not wanting people driving in the road, but again, they've been using that road and they don't even have access to it. So the road behind their house is not going to be well-driven. People are not going to drive in there because that gate's up. And then on our side, because we have another access road on the other side, and I do have pictures, by the way, that I'm going to give y'all to show you what I'm talking about. As far as the ALF that's there, that is called Angels Unaware. And for those of you who know anything about the Angels Unaware, they are unfortunately people who are bound to wheelchairs or beds. And there's maybe 2 or 3 residents that live there and have lived there. And Angels Unaware came to all the homeowners before they even bought that house to make sure it would be okay. And of course, it has to go somewhere. And yes, it's a business, but it's a business taking care of people who can't take care of themselves. So the only people you see there are the people who are taking care of the people who are incapacitated inside the house. The only way they go anywhere is through a van that picks them up to take them to doctor's appointments or the hospital or eventually the morgue. So that's the Angels Unaware are not going to be out in the backyard trying to look over a 6-foot privacy fence. I just feel like the 8-foot fence is excessive, to say the least, and there are no other ones in our area. The ones they're talking about are way down the road in a whole different section, and it's uneven ground, and that's why the fence is 8 foot. So, like I said, I don't have any objection, and I'm not the only neighbor that objects. The Browns virtually sent some information online. Joanne and Tom Brown, who have access to both those roads, and they're the only one that has access to both those roads. Right now, they're fighting the people who put up the gate. And by the way, there's a fence down at the back of that property, so people there's no way you can cut through anymore, okay? And we keep our gate closed. If we open our gate, people will try to cut through there, especially teenagers. And Amazon is the worst offender of all. Let's see, they just, like I said, they just built that fence, and I can understand their concerns, but I also think that they should be within the code. And the fence company knew when they put it up, the 8-foot fence was not the code. So I actually have pictures that I'm going to give you all. I don't know if you want to put them on the screen or not. You know how to do this? I'm not sure. Stick them up here. All right, thank you. You're wonderful. All right, this is the road they're talking about. This one right here, which is a dirt road that runs behind their house. Okay, and they're saying that's their side yard. I can see a 6-foot fence there, not an 8-foot fence. This is our access road right here. That's partially paved and again turns to dirt all the way down. But it's a dead end road, it's Horn Road. But if you look at a map, it says it goes through. It does not. It is a private drive that we take care of ourselves, as this dirt road should be done. Okay, so there's one, you're gonna have that. Now this shows their fence and the 6-foot privacy fence of the Angels Unaware. Again, there's nobody in the backyard. There's nobody gonna be in the backyard. The only people that are there that are moving around are the caretakers taking care of those poor sick people in the house. And like I said, they came to all of us and asked us 25 years ago if it was okay. And of course, you said, God, yes, you got to do what you got to do. So there's that. Then this is their fence. And again, we have a wire fence in between the 2 private drives that access our property and the properties behind us. And there's only one property that has access to the other side behind their house. And that's the person who's put up the gate because they're trying to sell the house that's there. There are only 3 houses in that subdivision. And one of them is a guy who sold him the house, sold him the property, and didn't tell him all the stuff that was wrong, which I'm sure will come up again. And then this is a road that we live on. And you see there's fencing there, but that fencing is, again, wood, not plastic. And at the very end here, we have a gate that we've put up at the very end, so people can't cut through. If we leave that gate open, Amazon comes flying like it's a bat out of you know what to get to the subdivision behind us. And again, I stop them. I tell them, call the police for trespassing. I take down their ID, and I try to call Amazon, but they don't care. So anyway, the GPS is wrong. Again, I would hope that, you could not grant this variance for an 8-foot fence, let them use the 6-foot, which is to code, and it's not going to hurt them. The 6-foot's going to be quite nice. Of course, I'm sure the fence company's happy they sold them an 8-foot and would love to come back and put a 6-foot up. Does anybody have any questions for me? Have I made myself clear enough, or?
I think so.
Okay. And like I said, it's not just me, it's also the other neighbors and Tom and Joanne Brown who supposedly submitted stuff online before the hearing was postponed. And I just really appreciate it. Again, these are not through roads. No one's going to be in their backyard. They have a beautiful home. They put up a beautiful pool. They should put up a beautiful 6-foot privacy fence and be allowed to do that, but not 8 foot. God bless you. God bless America, and happy Thanksgiving, and thank you for everything you do.
Thank you.
Thank you.
Anyone else want to speak to this, the issues that have been raised by this particular offense? Yes.
Actually, sir, before the final applicant returned to us for comment, I just want to note that generally speaking, building permits are not required for installation of fences in the county. Earlier, he had questioned about whether they gotten permits. Generally speaking, you did not require to get permits to install fences in Hillsborough County.
All right.
I don't know who that person is. She doesn't live directly within our area, but it's hard to say that you don't think people are pulling into our backyard, because it has been a huge safety issue. And going around the county, there are 8-foot fences that separate businesses from residential all over Hillsborough County. Lutz Lake Fern, just within our area, Lutz Lake Fern, Ehrlich. On Lutz Lake Fern, there's a dirt road exactly like ours that separates, there's an 8-foot, it's the same exact fence that we have that separates that business from our, from that dirt road. We're just doing the same thing. We did not understand that there was a business in our backyard. When we moved in, their property is in disarray. I can't answer to why, or, but the separation of our HOA, which was approved, to the businesses that, and the dirt road that have nothing to do with our neighborhood, is the reason why we put that there. So it wasn't to try to build a wall, or it's completely for safety and has been approved, or it's erected throughout Hillsborough County.
Ma'am, can you please state your name for the record again?
Jennifer Dawson-Waz.
I'm Jason Waz, and the 8-foot fence is required behind Angels Unaware because of that structure that's in their backyard. And the reason for the 8-foot fence everywhere else was to try to keep it congruent, and also on the east side to keep people from driving into our yard, running over our child or our Yorkshire Terrier. And we haven't heard from anybody. She said there's other neighbors that have objected. We sent all the notices out. We only heard from one neighbor that called us the day after we sent the notice out. He lives on Crenshaw Lake Road, and I won't say what exactly he said, but in many expletives, he said he hasn't, he feels like we should be able to do whatever we want to do on our land. And, I know there's rules, but there's only one person that contacted us, and that was for us keeping our fence. Nobody else contacted us. Like I said, there's 2 homes behind us, 1 home 2 streets over to our east. Nobody contacted us whatsoever. Up until now, this is the first that we've heard of it. And I looked at the record yesterday on the Hillsborough County website. There are no documents from anybody objecting to anything on the website in the record. So
thank you.
Thank you.
Yeah, and just to close, we are, I'm a teacher and my husband is a physical therapist, and we are, respected people in our community. We're also small business owners, and in no way will we try to do something that would, be illegal or, hurt somebody else. So we've spent a lot of time and, having this fence erected, having our neighbors have this fence, having the same situation within miles of our house. We had no idea that we would pay for a fence and have to possibly remove it, especially for safety concerns. So, I just want to finish with that, we're in no way trying to hurt our neighbors. Our neighbors haven't come to us and said anything to us. We actually texted 2 of our neighbors to tell them that we were putting the fence up, which are 2 neighbors to our right. So, which would, have been affected by the fence. The person that is here, we believe, is not directly affected by our fence at all in our property line.
Thank you.
Thank you.
No,
Can I just show you the land use that you sent me?
no, you had your chance.
Well, y'all sent it to me, so y'all have.
That closes case number 20-1125.
Our next case is item G4, variance application 20-1129. The applicant is Karen Wagner. The request is a variance to accessory structure requirements. Staff findings will be presented by Tanya Chapella.
Tanya, go ahead.
Sorry, I can't start my video. I have an issue here. Okay, do you see me?
No, not yet.
Okay.
Now we can see you.
Okay. Do you hear me properly?
Yes, we can. Go ahead.
The applicant is requesting a setback variance for a proposed detached workshop carport on a single-family parcel zone agricultural rural AR. For the Land Development Section 61104 C1, accessory structures are permitted in front yards at twice the depth of the required front yard or 50 feet, whichever is less. The required front yard setback in the AR district is 50 feet. Therefore, a minimum front setback of 50 feet is required for the proposed workshop carport. The applicant requests a 47-foot reduction to the required front setback to allow a setback of 3 feet from the west property line. I'm glad to answer your questions if you have any. Thank you.
I don't think we have any questions for you at this time. Yeah.
Ms. Wagner, please go ahead.
Good morning. My name is Karen Wagner. I live at 9534 Bryant Road in Lithia, Florida. I am here today with my husband, Daryl. I have previously spoken to Steve Koliger in Development Services, as well as Joe Reinbold in Zoning and Lori Boland regarding the small workshop that we are asking to build in our backyard. They agreed that not all county regulations apply to every situation, and this is a unique situation that warrants speaking to you all about an approval for a variance. As you will see in the variance packet, we live on 11 acres on a flagpole lot, which is about 700 feet from Bryant Road. Our home faces south. We consider the back house or backyard of our house to be facing north, and we are asking for a variance so that we can build a small workshop on the back side yard of our property. We were informed by those other people that this is considered, it is our side yard, but it is considered our front yard per the county regulation, and it runs the same direction as Bryant Road. And we are so far from Bryant Road that our home is not visible at all. We have provided a notarized letter from the neighbor that borders the fence line where we want to build the structure, Mellery and David Forkey. They have a pasture there with about 10 acres, a horse pasture, and that is where we want to build the small workshop. And they are in agreement and have signed a letter and sent it in to you all. So you have their approval as well. If we went 50 feet from that fence line, we would be directly in our backyard. So we need to be close as possible to that fence line, and we're asking for a variance approval there for that structure.
Thank you. Are there any other persons in support of application 20-11229? Anyone in opposition to application 20-1129? All right, thank you. We will close the hearing on application 20-1129.
All right, our next case is item G5, variance application 20-1162. The applicant is Razel Gonzalez Viltre. They're requesting a variance to accessory structure requirements and a lot development standards. Staff findings will be presented by Isis Brown.
Good morning, Isis Brown, Development Services. The applicant is requesting multiple variances for an existing single-family dwelling and a proposed accessory dwelling on a corner lot zoned residential single-family conventional RSC 6. The variances for the existing single-family dwelling per Land Development Code Section 6.01.01, a minimum front yard setback of 25 feet is required in the RSC 6 district. The applicant requests a 10-foot reduction to the required front yard to allow a 15-foot setback in a required front yard functioning as a side yard on the north side of the property. For the proposed accessory dwelling, per Land Development Code Section 6.11.02E, an accessory dwelling must meet principal building setbacks. Per LDC Section 6.0101, a minimum front yard setback of 25 feet is required in the RSC 6 district. The applicant requests a 10-foot reduction to the required front yard to allow a 15-foot setback in the required front yard functioning as a side yard on the north side of the property. The findings: there is currently a code violation code case number 202000331 on the property for the accessory dwelling. If the variance is approved, the property owner must obtain a building permit. The second finding: the applicant has advised that the accessory dwelling will include and must include a bathroom and a kitchen. I am available for any questions.
Is the applicant present for this particular? Thank you.
Good morning. My name is Raciel Gonzalez. I'm here. I'm the applicant for the variance number 201162. I'm doing this application for variance to reduce my setback from 25 feet to 15 feet and 2 inches. I'm trying to do a mother-in-law for my mom because she's coming to live with me in the house. So I'm trying to do that for her. If you have any question.
So she's going to be living on this lot in a separate structure.
Yeah. Mm-hmm.
I don't believe I have any other questions. Is there anyone that, I think you have to give your name.
Thank you.
Thank you. Is there anyone in opposition or support of this application? Seeing none, I would close.
No, hold on.
I'm sorry?
Yep.
Can't see.
Yeah, hold on. No, I just want to ask the applicant something when he gets done signing in.
Okay.
Yes, if the applicant return to the podium, please. Yeah. Okay, stated by Ms. Brown, you've been advised that the accessory dwelling must include a bathroom and a kitchen to function as a dwelling. Would you confirm on the record that the structure will have a bathroom and a kitchen?
Yeah, it's going to be a small kitchen, a living room, a bedroom, and a bathroom for her.
Okay, thank you.
Thank you. At this time, we would close the hearing on application 20-1162.
Okay, our next case is item G6, variance application 20-1172. The applicant is Lori Jeffcoat, requesting a variance to the requirements for a temporary manufactured home for medical hardship. Staff findings will be presented by Laura Marley.
Good morning, Laura Marley, Development Services. The applicant requests variances for a proposed temporary manufactured home due to a medical hardship on the property zoned agricultural single family. Temporary manufactured home shall be located behind the principal building on the same lot and behind the front of the principal building on any lot abutting the subject property. The applicant requests a variance to allow the subject temporary mobile home to be located in front of the principal building on the same lot and in front of the principal building on the lot to the east and to the west. Also, temporary manufactured homes shall be screened or separated from public view from adjacent properties through the use of open space of a distance equal to 1/2 of the lot width requirement. The screening is required where the temporary manufactured home is less than 75 feet from the parcel boundaries. The temporary manufactured home is 30 feet from the east side property line, 60 feet from the front property line, and 50 feet from the west property line. The applicant requests a variance to eliminate the screening requirement. It should be noted that a conditional use application for the temporary mobile home was approved. However, during building permit review, it was identified that the location of the mobile home in front of the house required approval of a variance. The conditional use site plan also did the required screening. Thank you.
Is there someone here to speak in favor of this proposal?
My name is Harry Jeffcoat. I represent my wife, Lori Jeffcoat. The property we are requesting the variance on is 613 East Sam Allen Road. May note we own the property to the left and the property to the right, which is 611 East Sam Allen and 615 Sam Allen. As she said, we were approved April 1st on our medical hardship. The reason we went down that road, in February before this COVID hit, I went over to the zoning office with questions how we could put a second mobile home on our property. And one of the options was medical hardship. Well, my wife is severely disabled and just recently lost her right leg because of vascular disease and the COPD real bad. And we wanted to have family members near to help us. So that seemed to be the way to go. So like she said, April 1st, we were approved for that. But then, like she said, under further review, the mobile home has to be in the back of the primary. Well, there's flood zone in the back. Right now it's standing water on our property. And I have a survey here, it shows that, and would be unable to put it back there. So that's why we were placing it where we did or wanted to. And far as the privacy fence, we can do that, but we were hoping to change it to a chain link fence because there's no view. I got some pictures here I'd like to show. Good. Okay. All right. This would be the view to the west.
Can you please talk into the microphone?
Can you talk into the mic?
I'm sorry. This is the view to the west. As you can see, there's a driveway there. Then that's our lot. So there's no neighbor on that side. And you might notice across the street to the, it would be the north. See that high fence? That's a 14-foot fence. I'll show you in my next picture, which would be our front yard view.
Talk into the mic, please.
I'm sorry, would be our front yard view. Kind of going backwards here. Okay. Anyway, that would be our front yard view. And the road there, we're 4-laning right now, is why they put up that 14-foot sound barrier across the other side of the street. So there's no neighbors that could see us anyway. And we actually sit 2 foot below the road there at the highest point on our property. And even if we put a fence, you see that railing, a 4 foot, I mean, we'd have to put a 4-foot fence there by code because it's too close to the highway. So it wouldn't block any view at all. We wouldn't even come up to the top of that railing. This is the view to the east. Again, that's our property over there, so there's no neighbor to obstruct, to see us.
Can I ask a question, please, sir?
Pardon me?
I'd like to ask you a question.
Okay.
Could you put that other picture back up for a minute?
This one?
Yes. I see there's a septic area.
Yes, that's where we actually have a permit for that, because when we got the go-ahead, that was one of the things we proceeded to do. And that is where we plan to put our septic.
For this separate building, or for what you want to construct?
Well, we're putting a mobile home there.
Oh, okay, all right.
Yeah, and the history behind that, my uncle died, and my aunt wanted to sell the mobile home, so it's a better mobile home than we currently have. So we purchased it, and we're also under a deadline because across the street there where they had property, the people had bought the property, just gave us to, I think, February to get it out of there.
So it was a mobile home?
Yes, it's a mobile home. I'd also, I'm going back to this picture simply because I wanted you to see in the background, it's a mobile home park, and there's actually existing mobile homes closer to the road than what we would be. And we would be conforming to what the neighborhood looks like. Across the street is a huge mobile home park as well, but it's hidden behind that wall. This is just a view of the backyard. That's the existing mobile home and a barn. We used to have a horse, but we don't anymore. I'll probably keep lawnmowers in it. But the mobile home that's there now, it's a good chance it won't be there after we do all this, because the family living in it will move to our 611 address. And, that's kind of up in the air. We really didn't know how to go about getting the second mobile home on the property, but it just seemed to be the right way to go because of my wife's medical history, needing the family.
Sir, let me ask you a question.
Sure.
Is this where do you want to place the mobile home?
I got a survey here. I'll show you.
Okay, thank you.
Okay, this would be the, whoops. This would be the north.
Speak into the mic, please.
That would be the north. Okay, this is the proposed mobile home right here.
And where is your house?
We actually live on the property next to it, somewhere back in here, 611 East Sam Allen Road.
And where is it that the code would let you put the mobile home?
Pardon me, I'm sorry, I don't hear so good.
Where is it that the code would let you place the mobile home?
Well, they were saying because it's a medical hardship, it had to be behind the primary. But as you see back here, all that is underwater. We wouldn't have any place to put it. And that's why we proposed to put it in the front. And we thought we were okay. Like I said, on April 1st, we got the approval. But then we were actually, after we got the septic permit and we started to put some dirt in there for the mound, we found out it was supposed to be in the back and we'd have to get a variance.
Thank you.
Okay. I hope I made myself clear. Also, we would rather, if possible, put a chain link fence, since really the privacy fence is not going to hide. There's nobody to hide from. Nobody can see over that 14-foot wall, or there's no neighbors left or right. And I feel like we'd actually be conforming to the way the neighborhood looks.
Thank you.
Okay. Is there any other questions?
Anyone got any questions for this?
I guess, we have to do a setback because we're a little too close to the property line. 30 foot, I think, has to be a little bit more. But again, if all the property was lumped together, it would be like 150 foot on each side. So each lot's 150 foot wide.
Thank you.
Okay.
Is there anyone else here in support of this application?
I'm sorry, I didn't hear him.
You step forward.
Okay, I'll bring this over there.
Once again, is there anyone else in support of this project? Is there anyone in opposition to this project? Well, then I would move that we close testimony on this project.
The next case is item G7, variance application 20-1275. The applicant is Shannon Netherton. Requires a variance to lot development standards and to kennel development standards. Staff findings will be presented by Tanya Chapella.
Tanya Chapella, Development Services. The applicant is requesting 2 variances to accommodate a proposed kennel on property zone CE. Per the Land Development Code, Section 60101, the required minimum from setback for property zone CE is 30 feet. The subject property is a corner lot with required front yards on the south and west sides. The applicant requests a 10-foot reduction to the required front yard on the west side of the property to allow a setback of 20 feet from the west property line. The second variance is to kennel requirements. So per the Land Development Code, Section 61152, kennel provisions, kennel exercise area shall be 50 feet from any residential zoning district. As shown on the site plan submitted by the applicant, the outdoor exercise area is set back 12.1 feet from the east property line, adjacent to a parcel zone RSE 9 that is developed with a church. The applicant requests a 37.9 foot reduction to the required distance to the adjacent property to allow a distance of 12.1 feet to the east property line. This concludes my presentation. I'm glad to answer any questions if you have any.
I think then we can move to someone who is in support of this project? If they would approach the podium, please.
Hi, I am actually.
You would ask for the applicant at this time?
The applicant?
I am presenting virtually. Can you guys hear me?
All right.
Go ahead, Tyler.
Okay. All right. Thank you. I just want to make sure that everyone can hear me before I present.
Tyler, are you the applicant for this?
I am not the applicant, but I am here on behalf of the applicant.
Can you punch him into the room? Tyler, can you say that again, please?
I am not the applicant, but I am here on behalf of the applicant. I am the representative. Perfect. It looks like I'm visible. Can I go ahead and proceed?
Yes.
Thank you. So as an overview, it's a company that provides boarding and daycare services for both dogs and cats, with an emphasis on daycare boarding. They do offer overnight boarding, but it is not the primary objective of this use. One of the things that this program provides is the ability for dogs to have an outdoor exercise area. And with that, there are no overnight outdoor boardings. Everything is basically moved interior to the building during the day. Animals are only placed outside for a limited period of time during the day. There is no animals outside during the evening. And one of the things that we work through staff with to design this property, actually a couple of different issues that we're working through. We have two known floodplains that we are providing compensation for. They're both located in the rear of the property. There currently isn't an existing stormwater system, so we're hoping by implementing some floodplain compensation and stormwater ponds to meet the Southwest Florida requirements that we can make a positive impact in this area. In addition, there are known wetlands at the rear of the property that limit our ability to develop. Our goal is to not have to impact the wetlands, which is why we situated the site where it's currently at. And lastly, we had another item that we worked through with staff. In the future, it was mentioned that Gun Road has the potential to expand and additional right-of-way may be required. And it was suggested by staff to move the building farther back from the road to accommodate any further development. So that presents my case. If there are any questions, I'm happy to answer now.
Your name and address for the record.
It's Tyler Suddeth. I'm with Kimley Horn, 189 South Orange Avenue, Orlando, Florida, 32801.
And if you don't mind me asking, how are you connected to the owner of the project or the people that want to do this project here in Hillsborough County?
My client's a developer that is working with the property owner. The property owner is going to sell the property.
Sell the property?
Correct, but I'm working directly for the developer who is working for the end user, which is Pet Suites.
Are there any other people here in support of this project? Anyone here opposed to this project? Could you please come forward? Are both of you going to speak?
Yeah.
All right.
My name is Margaret Hess. I live at 12516. Okay. There. Margaret Hess, 12516, Pittsfield Avenue, 33624. I've lived there about 37 years. Throughout that 37 years, there's been so much rezoning. We have developments that are surrounding us now, and as you know, whenever land turns to commercial, they build up. We're on septic, and we don't have city sewer. It's causing a problem whenever we have the rainfall. or on a well. Whenever there's construction, what they've told me is we get dirt in our water. And they say a lot of times that that's due to construction in the area, turns things up. Once we have that, there's just one more issue out in the front of where we live. The traffic that would be caused by this, people coming in and out, about 10 years ago or so, we had speed bumps and stop signs installed. The amount of traffic through these developments that have been going on for the last 30 years surrounding this there's 8 roads that are about a quarter of a mile, and then another 6 roads that are about a quarter of a mile. So we're boxed in by all this land variances, all these changes. We're going underwater now. No one's looking out for us as far as our drinking water or as far as the septic system. It's harming the green area that we have. There's no sidewalks in our neighborhood. So it's just a problem when you continue to make commercial areas in what's being zoned as what is originally residential. The request for a 37-foot reduction is excessive in that particular lot. They're saying that they would have ponds to accommodate for the runoff. We're already underwater whenever it rains because we have ditches. And the ditches aren't maintained very well by the county at all. They're saying that there's no overnight boarding. That's how they're going to start off. That's how it always starts off. Eventually that will change. It will expand. They had mentioned that there's a possibility for expansion. And again, I would ask you to look at the reductions that they're asking for in the setbacks. I do believe that that's excessive. For this kennel, there's also the noise for the animals out in the runs. This is highly residential. There's a park there, the children playing. If any of the animals got loose, would that pose a danger to the residents that live there now? Thank you.
Thank you, Ann.
My name is Beatrice Valenti, and I'm just here in opposition as well. I second everything that she said. This is a residential area. Sorry.
Do you live in this area?
Yes, I live with her.
Please give your address for the record.
12516 Pittsfield Avenue, Tampa, Florida 33624. So I'm just seconding what she said, that this is a residential area and we do not support this commercial stuff coming in.
Is there anyone else, either virtually or in the audience, speaking against this proposed change? Seeing none, we will close the hearing on this.
All right, the next case is item G8, variance application 20-1276. The applicant is Rachel Menger. The request is a variance to fence requirements. Staff findings will be presented by Isis Brown.
I apologize. Is there an opportunity for rebuttal? Regarding the previous case?
Rebuttal on the previous?
I just wanted to answer some of those concerns.
Well,
Glad to reopen it. The opposition is here.
All right.
The applicant should be given final comment.
All right. The answer is yes. We can reopen it.
Okay, thank you.
Go ahead, Tyler.
Okay, I appreciate that. And thank you for the comments, Beatrice and Margaret. I certainly understand your concern, but just wanted to address a couple of things that you mentioned. Just wanted to clarify that we are not rezoning to a commercial development. The current zoning is a commercial zone property, and we are allowed to develop what we intend on developing. And in relation to the septic system concerns, right now the existing development is on septic. And as we move forward, we are designing a lift station to directly connect to a forest main, basically eliminating the septic that is currently on the site. And third, in regard to stormwater, we certainly understand that this area may be prone to flooding. And by doing so, or by moving forward with this development, we are providing additional compensation above and beyond the normal requirements to offset any flooding issues. So right now, there really isn't any structure or any infrastructure that provides stormwater control. And so by moving forward with this development, we will be updating the infrastructure in the area to ensure that we are not flooding the adjacent surroundings. And lastly, we specifically put the play area over up against the east property line, where we have a shared property line with the church, and it's isolated and over on the church side of the property line. They have stormwater infrastructure, so it's set far back from any primary structure.
Let me ask a question that maybe I should have asked earlier. The 50-foot down to a 12-foot 1-inch reduction seems quite excessive. What is the rationale for that very, very large reduction?
So right now the property width is 150 feet, and with the building and the play area, if we were to put the play area on the opposite side of the property, we would be left over with a limited amount to develop. And so we certainly understand the decrease in the buffer, but we've located it in an area that we feel minimizes any of the impacts to the surrounding areas. We're limited in placing it in the rear of the development just because we have the floodplain that we have to compensate for, in addition to wetlands that we are not encroaching and providing an adequate wetland buffer to ensure that we maintain the existing habitat. And I just want to touch on one more thing too. I know it was mentioned that we're going to expand in the future. That's certainly not the intent. I brought up expansion to Gun Highway because it was mentioned during our review with staff that it was suggested that we set back our building an additional amount of feet from the required building setback, just because it's going to benefit the county as the county moves down into the future, if they ever intend on expanding Gun Highway.
Did you mention that the rear of this property is in a floodplain?
We actually have two different floodplains, and both are located at the rear of the property. One is along the western side, which is where there is an existing ditch that captures the runoff from 4 Oaks Road, and the other is essentially contained within the wetland area.
Is there any other rebuttal? Can I let her speak? Can I let this lady speak?
The applicant generally has less.
Okay. Well, I think I'm going to, please come up.
I noticed on the paper there, it said CG, and then in parentheses, it said R. So I was assuming that the CG was commercial. Is that what it was? And what does the R, is that residential? Because currently it's a house on that piece of property. It is a residence. I just, forgive me, I don't know what CG means next to it.
Yeah, CG stands for general commercial, and the R means restricted.
Oh, restricted.
So, yeah, so it's allowed general commercial uses with some restrictions. We'd have to look up the actual zoning to see.
Okay, yeah. As I say, it just seemed that the reductions that they're asking for are so excessive. At this point, wouldn't it be better just to look for a different piece of land? There's so many available in there that might suit it better, especially if they're looking in the future they're going to impact the wetlands. We have the ditch, like we said, as far as the sewer and the septic. They're going to be building up. It's going to be an imposition to the people who already live there. This is, as I said, 8 roads by 8 roads. This piece of property is right in the front of the beginning of that little development.
Well, thank you.
Thank you.
Can you state your name for the record, please?
Margaret Hess.
Hi, this is Tyler. Am I able to provide a rebuttal to that?
Number 20.
Mr. Chair, am I able to provide a rebuttal?
All right.
Thank you. I just wanted to clarify that we are not impacting the wetlands. We intend on providing a 30-foot wetland buffer, which is consistent with the county and water management requirements. And specifically regarding the swale that captures the stormwater from Four Oaks, we are increasing the width and depth of that swale to accommodate any runoff to help alleviate any flooding concerns. In an area right now that currently doesn't have much stormwater infrastructure and apparently is not being maintained well. By moving forward with this development, we are going to beef up the infrastructure and hopefully alleviate any flooding concerns by providing adequate storage for additional flooding events. Thank you.
All right. Then we'll now close number 20-1275.
And the next case is item G8, variance application 20-1276. The applicant is Rachel Minger. Request is a variance to fence requirements. Staff findings will be presented by Isis Brown.
Good morning, Isis Brown, Development Services. The applicant is requesting a variance to fence height requirements to accommodate an existing fence on a single-family parcel lot zoned ASC1 per Land Development Code, Section 6.07.02C, number 2. Fences in agricultural district shall be regulated in the same manner as a fence in the residential districts, except under certain conditions and circumstances that do not apply in this case. Per Land Development Code Section 6.07.02C.1, a minimum height of 6 feet is permitted for fences, excluding those located in front required yards and under certain circumstances that do not apply in this case. The applicant requests a 2-foot increase to the maximum permitted height to allow an 8-foot height fence for an existing fence located in the required side and rear yards. The findings, the existing fence is solid wood with a lattice top, and I share screen. Okay. And this is a solid fence with the lattice top, which is 8 feet in height. And this ends the my comments for this report, and I am available for any questions.
Well, if I might ask a question, what is the staff recommendation on this particular?
Staff makes no recommendations in variance cases.
All right, thank you. Withdraw the question. All right, I would ask if there are anyone in the audience that want to speak in favor of this.
Sir, you need to hear from the applicant at this time.
Good morning.
Morning.
I'm Rachel Menger. I reside at 2404 Green Meadow Drive. I could try. Thanks. So we are here. I'm here on behalf of my family. We're requesting permission to be allowed to keep the top 2 feet of our fence, those that are lattice like that. We ran into a similar situation as the Waz family earlier in terms of the fence company telling us it was fine and the guy saying, I've lived here 30 years and never needed a variance. We were wrong. We do apologize for that. Understanding that oversight was our responsibility, not that of the fence company. However, we have not run into opposition from neighbors. Our one neighbor who shares that fence line with us and had a fence there is very happy about it. I believe he's emailed in as well to state his piece on that. Our motives for the fence, primarily safety. We have a dog who's able to jump 6 feet, and so we thought having a higher fence than that would be better for neighborhood safety as well as the safety of our animal. We also have 2 young boys, so we were hoping, an 8-foot fence might discourage them from climbing a little more than a 6-foot. And the third reason being privacy. We bought a house in the country. We plan hopefully someday to put a pool in the backyard. And we're just hoping we'll be allowed to keep the lattice that exists on our fence. And we're open to any questions or concerns at this time. Thank you.
I don't believe. Yeah, I believe you.
Sure.
Now let me ask, are there any other persons in support of this particular application? Are there anybody here in opposition to this application? Seeing none. Those in 20-1276, we'll close the hearing.
Our next case is item G9, variance application 20-1277. The applicant is Charles and Tricia Powers, requesting a variance to lot development standards. Staff findings will be presented by Kevy DeFrank.
Good morning, everyone. My name is Kevy DeFrank with Development Services. Now, for this case, the applicant is requesting setback variances for a proposed single-family home on property zoned AR that is actually subject to the required setbacks of the AS-0.4 zoning district. Now, per the Land Development Code, the required minimum side yard setback in the AS-0.4 district is 25 feet, and the applicant specifically requests a 3-foot reduction to the required side yard to allow a setback of 22 feet from the south property line, and a 10-foot reduction to the required side yard to allow a setback of 15 feet from the north property line. And our findings include the subject parcel is 1.07 acres in size and 102 feet in width. However, the AR district requires a minimum lot size of 5 acres and a minimum lot width of 150 feet. And the applicant obtained a legal non-conforming certification per NCL 20-1372, which is in the record, and it's subject to, or the subject property is subject to the setbacks of the AS-0.4 zoning district. Also, the applicant stated that they intend to demolish the existing home, single-family home on the property, in order to construct the new proposed single-family home. Thank you, and I'm available for questions.
Good afternoon. My name is Cammie Corbett. I'm with the law firm of Hill Henderson, and I'm here representing Chuck and Tricia Powers this morning, or this afternoon. And my address is 101 East Kennedy Boulevard, Suite 3700. And Jamie, our whole team was not in the room when the swearing in occurred. So if you could have us all sworn in, I'd appreciate it.
Do you represent that you're going to tell the truth, the whole truth, nothing but the truth?
We do.
All right.
Thank you. And Jamie Mayers from my office is going to provide a presentation.
And this is Jamie Mayer for the applicant, 101 East Kennedy Boulevard, Suite 3700, Tampa. I have a PowerPoint to upload. It's on a flash drive. Okay, thank you. Oops. So as staff explained, this is for property located in Odessa, which is zoned AR, but sorry.
Can you just please you probably did already, but just put your name on the record, please.
Sure. Jamie Mayer for the applicant from the law firm Hillsborough Henderson, 101 East Kennedy Boulevard, Suite 3700, Tampa, Florida.
Thank you.
Yes. Thank you. So it's zoned AR, but because it's a non-conforming lot and we had to apply for a legal non-conformity in connection with this request, by default, the next lowest zoning district applies, which is the AS 0.4 zoning district, as staff explained. However, the setback requirements for the AS 0.4 zoning district are exactly the same as the AR. Therefore, we still need a variance. The only difference really is that the AS requires a lot size of 2.5 acres and AR requires a minimum of 5 acres. But as staff explained, the lot is just over 1 acre in size, so it can't meet the dimensional requirements of either of these. Therefore, we still need a variance, and it's still a non-conforming lot. It does, however, meet the size requirements, the width requirements, and also the siding of the existing home, or the siding of the proposed home will meet the dimensional requirements of the AS1 zoning district. I'll show you some aerials later, which indicate to me that the property was improperly zoned AR. The surrounding area is all AR, and it makes sense, and you'll see why it does not make sense that this particular lot was zoned AR. It should have been zoned AS1. And it's also irregularly shaped, as you'll see, with a relatively small buildable area, which really constrains the location that a building could be sited on the lot. Okay. As stated by staff, the applicant intends to demolish the current home on site, which was built in 1972, and they're going to rebuild an upgraded home with a substantially similar footprint as the existing home, because as I said, the buildable area is pretty small, so there really aren't a lot of different places that you could place it. It's important to note that the existing home itself does not meet AR or AS 0.4 setbacks because of the lot size, the width, and the irregular shape. So in our specific variance request, again, to reiterate what staff said, is we're reducing the south side yard setback from the required 25 feet to 22 feet and reducing the north side yard setback from the required 25 feet to 15 feet. Here's an aerial. The subject property is outlined in red. You can see a not inconsequential amount of the acreage is taken up in that long, narrow portion, which provides access to the property. And then you can see the buildable area is that rectangular spot where the existing house is pretty much in the middle. And you can see it's significantly smaller than the surrounding lots. And to zoom out to give you a little more context, the surrounding area is characterized by relatively uniformly rectangular lots with large buildable areas that easily meet the minimum, not only the minimum lot size requirements, but also the minimum widths. So it's obvious why this area was zoned AR. It's simply the fact is that the existing lot that we're dealing with just shouldn't have been lumped in with that because it cannot, never could have, and will never be able to meet the AR zoning district requirements. Here is on the top, the footprint and siding of the existing home. As you can see to the north, it's 17 feet from the north boundary, and it's currently only 10 feet from the south boundary. You can see the proposed home, as I said, is relatively in the same footprint of the existing home. However, it's going to be 22 feet from the south boundary, so it's actually going to increase the existing setback condition. It's going to be farther from the south boundary and then only 2 feet slightly more towards the north for a total of 15 feet from the north boundary. Both the adjacent south property owner and adjacent north property owner have expressed their support for the request. As you can see from these letters, also not only have they know of the request, but they also, as you can see, understand the specific way that the request will affect their relative properties. With the south owner understanding that, you know, it'll be 22 feet from their property, and the north owner understanding that it'll be 15 feet from their property. And with this information, they still support the request. Just to kind of break down again the difference that will result on site if this variance is approved. Existing, north 17 feet, south 10 feet. We're going to basically end up with a 2-foot decrease to the existing condition in the north and a 12-foot increase to the existing condition in the south. To address the variance criteria, this hardship, as I've shown you with the aerials, it's clearly unique and singular to this lot. The surrounding area does not suffer from this hardship because they're all 5 times the size or more of the lot that we're dealing with. It has an irregular shape, a relatively small buildable area, and it's simply impossible to site a home on site without at least some form of relief from either the AR or the now applicable AS 0.4 setbacks. A literal interpretation of the code here will deprive the powers of rights afforded to everybody else in the surrounding area. The AR setbacks would result in a home that's just, if you had to build a home within those setbacks, you would be constrained to a strange 50-foot or less narrow area to build the home, and it just is not feasible, as shown by the fact that the existing home can't even meet those. This would result in a negative impact to property values both on site and in the surrounding area. The variance is not going to interfere with others. It's not going to injure surrounding property owners. And as you can see from the letters submitted by the adjacent property owners, they're supporting this request. And importantly, within the surrounding area, an improved and more attractive home will benefit the neighborhood as a whole. And again, it's not going to really change from the existing location of the house. So really not much is going to change for the surrounding area. The variance is in harmony with the code and the comprehensive plan, which promote the orderly and harmonious development of the surrounding area and requires consistency with the size and the character of the surrounding homes in the area, which is exactly what we're proposing here. This is clearly not a self-created hardship. The lot size and configuration are very independent of the powers that existed on site long before they purchased the property, because it's a legally non-conforming lot since at least 1988 per our nonconformity approval. And the variance will result in substantial justice being done if you consider the public benefit that will result, as well as the hardship that would continue to exist for the powers if this variance was not granted. We're going to be promoting appropriate development of a large and attractive home in a neighborhood that is characterized by homes like this. In turn, this promotes preservation and improvement of property values, consistency and appropriateness of development with the surrounding area. And without this variance, a home simply cannot be constructed on the site due to irregular shape and non-conforming size without some relief from the setbacks. Well-established principles of case law support our request. In Joanne B. City of Coral Gables, which I am submitting into the record, all of this, by the way, including copies of the case law. There's a zoning district that requires 50-foot lots width for residential buildings, and in that case, the owner's lot was less than 50 feet. The court found, applying the test above that I've put on the screen, the property owner was entitled to the variance because the hardship was peculiar to the lot, related specifically to the land. The hardship was not self-created because it was a non-conforming lot and had been for many years. The variance would not alter the character of the zoning district, nor would it injure neighboring properties. Our case is just like this. The hardship is peculiar to the lot, as you've seen, in comparison to the surrounding area. It was not self-created because it's a legally non-conforming lot. And what we're doing with the proposed new home would not alter the character of the zoning district. It's going to be pretty much the same as it is, just slightly different setbacks, and the neighboring properties are completely in support. And finally, in the city of Coral Gables v. Geary, which is also a third DCA case, the court found a property owner's hardship was not self-created, where the unusual shape of a property rendered it literally impossible to develop in accordance with the regulations. And the property owner had purchased the property knowing this, and it was still afforded a variance. The Powers lot suffers the same kind of hardship, where it shouldn't have been zoned AR. It can't even meet AS 0.4 standards. It can meet AS 1. Therefore, we find this is an appropriate request, and we respectfully request that it be granted. Thank you.
Thank you. Any questions for this witness? Any opposition? Seeing none? Thank you very much.
Cami Corbett again for the record. I don't think we have anything else to offer unless there's any further discussion that we might need to respond to.
Thank you. At the request of the hearing officer, we're going to take about a 10-minute break. Oh. Okay. And for purpose of this, I will close the hearing. Oh, I'm sorry. Yes, on the case that we just heard, which is application 20-17 or 1277. And then we're going to take a 10-minute recess.
Hello, everyone. If you're still on the line with us, if your case hasn't been called at this time, please stay on the line. We are in a 10-minute recess at this point. Thank you.
All right, this is the land use hearing meeting held on the 24th of November of 2020. And we've been on a short recess and we are now back in ready to take the next case.
Yeah, so sir, the next case is item G10, variance application 20-1281. The applicant is Audrey Rasa. Request is a variance to access easement with and a variance to allow a flag lot in the urban service area. Staff findings will be presented by Chris Grangillard.
Good morning. I'm Chris Grangillard, planner with Development Services. I'm here to present application VAR 20-1281. The applicant is requesting a variance to allow a 15-foot easement to serve a proposed two-lot subdivision of a parent parcel zoned ASC1. The applicant is also requesting a variance to allow a flag lot in the urban service area. Per LDC section 60101, a minimum width of 30 feet is required for a proposed access easement that will serve 2 or 3 lots. The applicant requests a 15-foot reduction to the required access easement width to allow a width of 15 feet to serve 2 lots. Also, per LDC section 60101, a single parcel to serve a single dwelling unit, a flag lot, may be recreated in a certified parcel subdivision as long as the property is located within the rural area and agriculturally zoned. The subject property is agriculturally zoned but located in the urban service area. The applicant requests a variance to allow a flag lot in the urban service area. So here are the findings. An existing metal utility building on the property will not meet the required 50-foot front yard setback from the proposed lot line between the 2 lots as shown on the plan submitted by the applicant. The applicant has advised staff that the shed will be relocated to meet setback requirements. Therefore, no variance is requested for the setback. Also, new development in the urban service area is generally required to utilize public water and wastewater services. However, per LDC section 4020C, a parent parcel may be subdivided into 2 lots served by private wells and or septic tanks, provided that it's not feasible to connect to public services. Utilities review staff reports that the connection to a public water and wastewater is not feasible for the proposed subdivision. That concludes my staff report. I'll be glad to answer any questions. Thank you.
All right. Seeing that there are, excuse me? All right.
Amber, go ahead.
Sorry. Good afternoon. My name is Amber Tu. My address is 2002 Holloway Road, Plant City, Florida, 33567. I am the representing agent for Miss Audrey Rasa. As the report stated, Ms. Rasa is seeking a variance to allow a 15-foot access easement to serve 2 lots. We are also seeking a variance to allow a flag lot in the urban service area. If this variance is approved, the newly created lot will be owned by her daughter and son-in-law as they plan to build a home so that they will have better availability to help Ms. Rasa when needed. Thank you.
Any questions for this witness? All right, moving on. Is there anyone here who wants to speak in opposition to the application 20-1281? And seeing no opposition, we will close the hearing on 20-1281. Thank you.
All right, next case on the agenda is item G11, variance application 20-1284. However, this case was continued to the December 14th land use hearing officer meeting at the start of this meeting. So that concludes section G of the agenda. It now takes us to section H, which are our special use cases. First case is item H1, special use application 20-1212. The applicant is Texas Roadhouse Holdings. The request is for a 4 COP-RX alcoholic beverage permit, which requires a separation waiver. On the special uses, the applicant goes first, unlike the variances, and then will be followed by staff. And in special uses, staff does render a recommendation. So following the applicant's presentation, staff report and recommendation will be presented by Laura Marley.
Afternoon, Marilyn Healy with the law firm of Ackerman LLP, 401 East Jackson Street, Suite 1700 Tampa. I have not been sworn.
All right. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
No. Reorient it just a little bit that way. Okay, where you see that red box is where the proposed location for the Texas Roadhouse Family Restaurant is located. And the front part, I'm awful at this. Better. Thank you. Yes, this part.
Are you talking to the mic, please?
This part of the property is all zoned commercial. And it started back in 2005 when the county, Board of County Commissioners approved the overall development with commercial uses here and residential multifamily apartments in the back. So today we're here before you requesting a distance separation waiver for a 4 COP-RX alcoholic beverage development permit for the sale of beer, wine, and liquor at the restaurant in connection with our adherence to the 51% total biannual sales derivative from the sale of food and non-alcoholic beverages in a gross floor area in excess of 2,500 square feet and 100 or more seats. In this case, we have 281 restaurant seats and 7,163 square feet indoor and a small 275-foot outdoor area. So we comply with that. We need a distance waiver between the apartments, which are behind us.
Can you talk into the microphone, please? You can push it towards you.
Thank you. The apartments, which are behind us and the back of the building, we're about 100 feet. And 150 is required. So we do believe that, and as you'll see in the staff report, that special and unique circumstances exist so that this proposed use does not impact significantly the surrounding uses and that the necessity for separation at that level is not required. This is one of 2 restaurants to be constructed at the Falkenberg Commons. Based on the 2019 approval, which is PRS 190605, and which was on the heels of RC 050213, the Board of County Commission approval, the County Commission and the hearing officer specifically found that this whole area was compatible and consistent with multifamily and commercial general uses, retail establishment, and some office, compatible with the RMU 35 comp plan and the PD development zoning plan. The initial commission approval in 05 and the PRS 2019 approval show where the Texas Roadhouse is being built is in the same general location as the other retail that was proposed at the time. In fact, these type of mixed-use developments conceptually attract multifamily residents because they want to walk to the restaurants and walk to shopping and have that convenience when they're located there. This is a family steakhouse. Probably roughly around 12 to 15% of their gross sales are related to alcohol sales. Their limited hours of operation, Monday through Thursday, 4 to 10, Friday, 4 to 11. Saturday is 11 a.m. to 11 p.m. and Sunday is 11 to 10 p.m. We are doing enhanced landscaping plan to buffer the area. There's also, how do I get that to expand for a second? I think it shows it better on this. All along here, there's going to be enhanced buffering. There's also some parallel parking on that 30-foot road. And then there's also the setback for the apartment complexes off of their property. The building itself is not open to the back. Everything is facing forward towards Falkenberg Road. So the fact that this isn't a big bar where they're going to have parties all night and all of this, it will really have no impact on the existing neighborhood at all. So respectfully, we are asking that you accept our position and approve this distance waiver in accord with the staff report. I have one other additional request.
Could you put the picture that you just had on back so I can ask you a question? So the roadhouse is away from the interstate.
Yes. See that red box?
That is the interstate there, right?
The interstate's to the east.
Right. Okay. Thank you.
Now, I know this, I don't know if anybody's asked you this, but I might be in a long line, but because of COVID, the county has been delayed as my client has been delayed in getting the surveys and everything and moving forward. Due to the hearing then being rescheduled another week and with the holiday delays, waiting the additional 15 business days to December 17th is really putting a hardship on us. We have about 135 employees ready to start their training and stocking and everything so we could be open for the holiday season. Obviously, I know that everybody is probably facing this, but this is a relatively small business and it will have a significant impact if we could get the order a little sooner. Thank you very much. And I'm here to answer any questions you have. My client, Alan Hansen, is the regional market manager, is on the line if you have any other questions related to the operations.
I don't believe I have any other questions.
All right.
Is there anyone here in opposition to this application?
No, hold on. Actually, at this time, we'll hear from staff.
All right.
Laura?
Good afternoon. Good afternoon. This request is for a distance separation for a 4-cop RX. According to the survey submitted by the applicant, the proposed wet zoning is 7,438 square feet. The distance from the proposed structure to certain community uses shall be 500 feet. This request complies with this requirement. The distance from the proposed structure to residential zone property shall be 150 feet. The request does not comply with this requirement. There is an apartment complex 100 feet to the east. The applicant requests a waiver to residential property within 150 feet and has submitted the following justification. The restaurant is part of a larger development which has been reviewed and approved in accordance with development criteria, and the landscape plan has been developed to appropriately screen the uses from adjacent residential apartments. Staff does find the request to be approvable. Thank you.
Thank you. We need any more. Is there anyone in support of this particular application that wants to speak either virtually or in person?
Alan, would you like to go ahead?
Yeah, my name is Alan Hansen with Texas Roadhouse. And just to kind of piggyback on what Marilyn had to say, you know, we do have quite a few employees who are looking to get started with this, but we just appreciate your time looking at this and are hopeful for a prompt approval. But that's all we've got. Thank you.
Thank you. Anyone in opposition? Seeing none.
Staff has no further comments. Is there anything more from the applicant?
Not at this time. Thank you.
Thank you. Okay. All right. At this time, I would close the application for AB 20-1212.
Our final case on the agenda today is item H2, special use application 20-1283. The applicant is CCRC OPCO Sun City Center. The request is for a 4 COP-RX alcoholic beverage permit, which requires a separation waiver. Staff findings will be presented by Israel Monsanto after the applicant's presentation.
Good afternoon, hearing officer. Neither I nor my clients have been sworn, so we'd ask that you do that at this point.
All right. At this time, I would swear both you and your client. If I could. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, sir. And congratulations on reaching the last item of the day. I know. My clients have gotten an education here as we've gone through this. I'm Ken Tinkler with the Carlton Fields Law Firm, 4221 West Boy Scout Boulevard in Tampa, representing the applicant. This location is better known as Freedom Plaza. With me today are two members of the Freedom Plaza team, just in case there are questions that come up as we go along. Freedom Plaza is a senior living community in Sun City Center, has a golf course and clubhouse. As the golf course shifted from a club-only operation to a club plus allowing public access, we are here seeking to change the existing alcohol approval from an 11C to a 4 COP SGX. Tom had to put up with me for a while and trying to figure out what to do with this one. And so thank you for that. We have found all the materials requested by the county and that are required by the Land Development Code for this type of request, as reflected in the record before you, and we would incorporate all those materials into our presentation. We did not receive any communications in response to the public notices that we received. This was designed as a mixed-use plan development approval. Dates back to 1973, which included the golf course and the clubhouse. It has operated as a community gathering point for many years, hosting regular meetings of civic organizations and others, obviously during more typical times. There is an assisted living facility that was constructed last year that is across the street. And because of the requirement in the code, it is within the 150 feet from the residential zoning parcel that is nearby. However, to actually walk between the assisted living facility and the clubhouse is well more than 150 feet due to the roadway, the parking lots, the landscaping, the driveway, et cetera. We're in agreement. As such, there's no negative impacts to the surrounding property owners. This has operated as an alcohol establishment for years, and the distance requirement is negated by the unique circumstances that you have before you. We're in agreement with what we understand to be staff's position that you'll hear in a moment, and we believe the record clearly establishes the support for the special use request. Do you have any questions for me at this point in time?
I have no questions for you.
Thank you. I'll wait to hear staff report then.
Yes, before Israel presents the staff report and recommendation, allow me to point out that the report incorrectly identifies the requested wet zoning as a 4 COP SGX. That's actually going to be the category it's a state license they'll request. The correct category of the wet zoning is 4 COP RX. And we will submit a revised staff report into the record after the hearing, which will correctly identify through the report that the requested wet zoning is a 4 COP RX. Apologize for the error. Israel, if you'd like to present your report.
Good afternoon. Can you hear me?
Yes.
Israel Monsanto Development Services. I have not been sworn in.
Do you testify to tell the truth, all truth, and nothing but the truth?
I do. I will share my screen here shortly. Do you see that?
Yes.
Yes, we do, sir.
Thank you. As stated by the applicant, this request is for a distance separation waiver for a 4 COPRX alcoholic beverage permit for the sale and consumption of beer, wine, and liquor, and sale or consumption on the permitted premises or patrons of a public golf club. According to the applicant, the proposed wet zone area will consist of 5,257.2 square feet. The site is located at 3932 Upper Creek Drive in Sun City Center. The proposed alcoholic beverage is located within a planned development approved for a mixture of uses, including single-family, multifamily, commercial, and recreation. Subject property is a golf club situated on a golf course owned under the same entity with at least 9 golf holes, and the golf course comprises more than 35 acres of land. There are 2 distance separation requirements for the 4 COP RX permit. Distance from the proposed structure to certain community uses shall be 500 feet. Per the submitted survey, no certain community uses are within this distance. The second one is the distance from proposed structure to residentially zoned property shall be 150 feet. According to the survey submitted by the applicant, residentially zoned property is located 110 feet from the proposed wet zoning. As you can see on your screen, the residential property is located to the south across Upper Creek Drive. In accordance with the Land Development Code, Section 61111E, a waiver has been requested by the applicant and justification has been submitted. In summary, the applicant states that this identical waiver is currently in place per an old special use approved AB 11-0429. The project is located in a mixed-use master plan community, and the assisted living facility building across Upper Creek Drive is separated by the roadway and extensive landscaping. Staff concurs with the applicant's statement regarding the distance waiver request from residentially zoned property. The wet zone area is separated from the assisted living facility site to the south by 60-foot wide right-of-way, in addition to landscape areas. The assisted living facility and golf clubhouse entrances are oriented so that they do not face each other, and the actual walking distance between the structure's entrances exceeds 150 feet. For these reasons, staff finds the proposed wet zoning does not pose significant impacts on surrounding land, and the necessity for the specified distance separation requirements is negated by the circumstances identified. Therefore, staff finds the request to be approvable. This approval is based on the wet zone submitted by the applicant, and if approved, the existing 11C wet zoning of the property approved under special use 110429 will be rescinded. And available if you have any questions.
I don't believe there are any questions. Thank you for your presentation. I'm sorry. I didn't hear you. Are there anybody that wants to testify in favor? There anybody that wants to testify against this proposal? Seeing none, I would close the hearing.
No further comments from staff, anything more from the applicant?
Just say thank you and happy Thanksgiving.
Thank you. Okay. At this time, having heard all the matters that were to be brought before us, I would close the hearing. I would say that the cooperation of the staff with myself as a fairly new hearing officer was much appreciated, and look forward to working for you in the future.